Hello everyone. Today's class is about the majority rule and minority rights or in company law or the rule in force versus Harbottle. A short discussion about this topic. Firstly, we will look into the powers of board of directors. We know that Companies Act distribute the powers between the board of directors and shareholders. The board and the shareholders exercise their powers through the meetings in a democratic way, and they will take decision in that meeting. The meetings include the meetings of the board of directors and the general meetings. The shareholders entrust certain powers on the board of directors, which is through the memoranda of association and articles of association. The board of directors have all the powers and can do all the things and act just the same as the company exercises its powers. That means for and on behalf of the company, that means company is a legal entity, and for that they are exercising all the functions. But the Act restricts the board of directors from the powers that only the shareholders can do in the general meeting. But there are only the restrictions imposed is that certain powers that can be exercised by the board of directors only with the shareholders' permission or the shareholders' decision in the general meeting. The power of the majority. The company stands as an artificial entity. The directors run it, but they act according to the wish of the majority. That is in a corporate world. The rules and decisions of the majority seems to be fair and justifiable, like a democratic way. The power of the majority has greater importance in the company, and the court tries to avoid interfering with the affairs of the internal administration of the shareholders. That is, the court will not interfere with the management of the company by its board of directors so long as they are acting within the powers conferred on them under the articles of the company. That means the board of directors or the directors acting under the memoranda of association and articles of association in conformity with the Companies Act. So the court will not interfere with the management of the company or its affairs of the company. That means the court will think that the affairs of the company's administration is in conformity with the law. The majority members enjoy the supreme authority to exercise the power of the company and generally to control its affairs, and the minority shareholders have to accept the majority decision. That means the majority decision, that means the company in the company administration, the majority will enjoy the supreme authority to take a decision, and the minority has to accept the majority decision. This may lead to the possibility that the members having majority vote may tend to oppressive towards the minority shareholders or misusing the majority strength. Because of this reason, the protection of minority shareholders within the domain of corporate activity constitute one of the most difficult problems facing modern company. That means the majority decision will prevail over the minority decision. Sometimes, because the majority will prevail over the minority decision, sometimes that may lead to the oppressive towards the minority shareholders' right. This lead to the difficult problem to the minority. That is, the general rule states that during the difference among the members, the majority decide the issue. If the majority crushes the rights of the minority shareholders, then the company law will protect it. That means if there is a difference of opinion among the members to take a decision, the majority decision will prevail usually. So if that decision crushes the rights of the minority shareholders, the company law will protect that the company law will protect according to the memorandum of association and articles of association. According to the company law, it says that the majority decision, in a democratic way, the majority decision will prevail. However, if the majority exercises powers in the matters of company's internal administration, then the court will not interfere to protect the rights of majority. That's because the court will think that the directors or the company will doing the duties or the administration according to the law, so that the court will not interfere. The rule in force versus Harbottle. This majority rule principle was established in the case Force versus Harbottle. That is the majority rule principle. The principle that the will of the majority should prevail over the will of the minority in the matters of internal administration of the company was founded in the case of Force versus Harbottle, which is known as the rule in Force versus Harbottle. The rule established in this case is known as the rule in Force versus Harbottle. According to this principle, the court will not interfere into the internal affairs of the company if the irregularities complained of could be legally done or rectified by the majority. That means if the illegality done is rectified by the majority, the court will not interfere. That court will presume that the things are done according to law. The majority rule stands for the proposition that the decisions and choices of the majority will always prevail over those of the minorities. Let us look into the facts of the case. In Force vs. Harbottle, the two shareholders, namely Richard Force and Edward Turton, commenced legal action against the promoters and directors of the company, alleging that they had mismanaged the company assets and had improperly mortgaged the company property. Thus, the property of the company was misused and wasted. The plaintiffs pleaded that the losses caused thereafter to the company be made good by the defendants. But the court dismissed the claim and held that when a company is wronged by its directors, it is only the company that has the standing to sue. That means the company is wronged by its directors. Though it's done by directors, the company has the only right person has the capacity to sue against the directors. That is, in effect, in that case, by dismissing, the court dismissed the case. The court established two rules. First rule is that proper plaintiff rule. It is that the wrong done to the company may be vindicated or to be rectified by the company alone. So, the proper plaintiff in this case is the company. And secondly, majority rule principle. It states that if the alleged wrong can be confirmed or ratified by the simple majority of the members in a general meeting, then the court will not interfere. That means earlier we have discussed about that thing. If it is majorities approved, then the majority rule principle applicable. That is, the majority decision will prevail over the minority. The court discussed that such an action cannot be brought by minority shareholders. In that case, the claim was rejected in respect of those transactions which a majority of the shareholders of the company had the power to confirm and ratify. In that case, that loss was made good by the defendants. So, that majority of the shareholders were ratified that and confirmed that. So, the company had the power to confirm and ratify, and the claim was rejected by the court. Thus, an action can be brought only in by the company. Company is the proper plaintiff for the wrongs done to the company. That means in this case, only if any action that can be brought against these persons can be done only by the company. Since the company acts through majority, the majority should have the power to decide whether to initiate the proceeding against the directors or not. In this case, the majority shareholders are not intended to proceed against the directors. This case, the principle established that the majority rule was established in Force vs. Harbottle, and this lead to the exceptions to the rule. The hardships and injustice that arise from the strict application of the rule on minority shareholders, various exceptions were recognized under which the majority rule may be excluded in its application. That means by this procedures and by this act of the majorities, there are situations or some exceptional situations the minority can protect their right. That is the exception to the rule. By that, this majority rule is not an absolute for the majority. The minority also have certain protection. That is what the exception to the rule. That is, the majority rule is not an absolute rule, and the minority have also certain protections. That is, if the act done by the majority under certain circumstances, the minority can take action to protect the interest of the minority. That is, if the majority done an ultra-vires act, a fraud on minority, a resolution requiring special majority but not followed, an invasion of personal right to the minority, and the wrongdoer in control and of the company, and if there is a breach of duty, and if there is oppression and mismanagement. And for that prevention of oppression and mismanagement also, that minority can take action to protect the interest of minority against majority. Let us look in one by one that exception situations. Ultra-vires Act. An individual shareholder can take action if they find that the majority has done an illegal act or ultra-vires act. The individual shareholders has the power to restrain the company. This is possible by the injunction or the order of the court. That is, if there is an ultra-vires act, majority has done an ultra-vires act, the minority can take an action against the majority. Fraud on minority. If the majority commits fraud on the minority, then the minority can take necessary action. If the definition of the fraud on minority is unclear, then the court will decide on the case according to the facts. Next, a resolution requiring special majority. If the act requires a special majority resolution passed, but the majority passes it by simple majority, then an individual shareholder can take action. If the wrongdoer in control. If the company is in the hands of the wrongdoer, then the minority shareholders can take a representation act for fraud. If the minority does not have the right to sue, then their complaint will not reach the court, as the majority will prevent them from suing the company. That means if the wrongdoer is in the control of the company, usually they will not interfere if the minority has no right to approach the court. Next, invasion of personal right. The majority shareholders are always obliged to the rights of the individual membership. The individual member has the right to insist on the majority on the compliance with the statutory provisions and legal rules. That means that the majority shareholders has the right to follow the statutory provisions and legal rules. If it is not followed by the majority shareholders, the minority shareholders have the right to insist for that. Next, breach of duty. If there is a breach of duty by a majority of shareholders and directors, then the minority shareholders take an action. This is also a case for the minority can take action against the majority. Next, prevention of oppression and mismanagement. To prevent, but if there is an oppression and mismanagement, then to prevent that oppression and mismanagement, the minority can take action against that. In short, we can say that the Companies Act 2013 introduced various provisions to safeguard the interest of the minority shareholders. The minority shareholders can move the National Law Tribunal if the affairs of the company are being conducted in the manner prejudicial or oppressive to the shareholders, or to seek an investigation into the affairs of the company. While the aim of these provisions are to protect the interest of the minority shareholder, that means the aim of this, that is exception to this rule, is to protect the minority interest. And efficient implementation of these provisions is still a challenge in the company law too. Thank you.